If you watched my video about anti-SLAPP, you saw that there are two types of law that get applied in federal court. Federal courts use federal rules for all things procedural. These are more administrative, for lack of a better word. When to file what motions, rules on discovery, page limits, schedules, fees, burdens, etc. When it comes to actual laws, a state law will be applied. That will determine what causes of action can be applied, how the burden is met, and it will be the deciding factor for whether or not a defendant will be found guilty, and what any damages will be. In a diversity case like this, there's a choice. The movie filmed in New Jersey, and even though Judge Lyman grasping at straws to keep the lawsuit under New York law when it came to dismissing Justin's claims against Blake, Ryan, the New York Times, etc., and in order to do that, he claimed that it was filmed in New York. That burned me at the time, because I knew that was incorrect. And now, bits of Blake's deposition are leaking, and so we see what she herself says about location. When asked about the filming, Jed Wallace's attorney asked, was that in California? And she said no, it was in New Jersey. He said, oh, I thought everything was in California. And then dropping down, was that also in New Jersey or was that in California? Talking about the second part of filming after the strike, where she says, that was in New Jersey. We shot a couple days in California at the end. So the only filming that involved cast took place in Jersey, with a couple of days at the very end in California. Never did the cast film in New York. There was supposed to be some filming done in Vegas, but Blake called out sick for that, and that scene had to be scrapped. The filming locations are going to be important in this episode, so keep this in mind. Now, as we know, Blake dropped her emotional distress claims, so these are her remaining causes of action. We see multiple SH claims, 3 to be exact, along with 3 retaliation claims. Why so many of the exact same thing? If you look, the first one is under Title VII, which is federal. The second one is under FEHA, which is a type of California law. And then we have the California Civil Code. And it repeats with retaliation. A couple of these didn't really have a specific rule that they went by, like these breach of contract, the defamation, or the civil conspiracy. But looking through, only the first 2 are based on federal rules. The rest have to do with California. Now, I forgot to scan these before I studied them, and this book is huge, so it's kind of a big deal to search, so you're stuck with my scribbles today. But we're going out of order, and we're starting with false light. False light is not recognized in New York. It is recognized in other states, and in this case, she's trying to apply California law, because it is recognized there. Now, what is it? If you think about it and you say, oh, you put someone in a bad light, you understand what that means. You made them appear a certain way. You portrayed them a certain way. That's the meaning of false light. Now, New York says it's too close to defamation. We're not going to waste our time with that. Whereas California says, well, when it comes to defamation, libel, and slander, those are cured if the statements are true. And if you remember, we discussed this a great deal back when Justin still had claims against these people, because that was the big fight. Was it a statement of opinion? Was it true? Was it hyperbole? There's another tort that's public disclosure of private facts. So this could be something like outing someone for some type of lifestyle. That's true, but it's embarrassing, and it was private. So that's a separate tort. Now, false light is about portraying something in a false or misleading way, even if the facts are technically true. Now, there are different types of torts. There are those that are put in place to protect from harm. These are usually based on the mental state. You have to show proof of harm to claim these torts. Then there are torts that protect a legal interest. These are infringements or invasions of someone's legal rights. So these torts that we're talking about are those that are put in place to protect someone from harm. So looking at the differences of these, if it's defamation, it's about compensating for harm to the reputation. Public disclosure of private facts compensates for embarrassment and humiliation. Now, false light is a little bit harder. It compensates for emotional distress and personal offense caused by a misleading portrayal. Now, you remember proving emotional distress is very difficult and is why Blake drops those causes of action. So that's going to come up again. Now, both false light and public disclosure must be publicized widely to the public, whereas defamation just needs to be repeated to one person. So we can see they're very similar, but they have their differences. You can understand why some states would say, well, we need something a little bit more than what we have and added false light, but you can also see why states like New York say, we've already got this stuff covered. We don't need this extra tort. So how does one go about proving false light? It has 5 key elements. This is considered a privacy tort. We all have rights to privacy. Not everything we do needs to be publicly disclosed. That's the first key element. Publicity. This can't be like defamation, just a couple of people or one person. This must have reached a large audience. Now, 2, there are some qualifiers here. It has to be highly offensive to a reasonable person. Now, when we talked about defamation before, we went through this, what this highly offensive and reasonable person, what they actually mean. It's a really high bar. In fact, such a high bar that you need to prove the emotional or mental distress that it caused you. It's not just, oh, what a terrible thing to say about someone. It has to have affected your mental state, and you must be able to prove that. The third one, there has to be clear and convincing evidence that the person who caused the false light knew that it would create a false impression. Now, this involves a couple of things. The actual malice standard, which applies because Blake is a public figure. But this false impression, it's an impression different from the plaintiff's true identity or character. So Blake is really going to struggle in this regard. Why? Well, if you follow the Bushbirds, they've been going through, and they're not the only ones that have done it along the way, so you may have seen it in other cases. But more recently, as opposed to the other accounts that I've seen do this around the beginning of this lawsuit, they went through and found remarks that were made about Blake from years ago. Specifically, when people on, for example, a subreddit that dealt with Colleen Hoover, so fans of the book, when they first found out that Blake was the actress in the movie, the things that they said. It progressed when people started to see the filming and saw her appearance. There's also been, and granted it greatly increased after her character started to be called in question, but all along her entire career, she has acted very offensively. Way back when she was on Gossip Girl, fans of Leighton Meester were often offended by ways that Blake treated her in public. One very specific comment was saying that she was born in a cage because her parents were in prison. She also famously tried to turn the cast against the man who turned out to be her boyfriend of many years when he first came to the show because she didn't like him. There was also a lot of criticism for her getting married in a plantation. There was criticism for her antebellum-style website. There was criticism for her doing a movie with Woody Allen. There was criticism with her friendship with Harvey Weinstein and the remarks that she made when he was first accused of assaulting, not harassing, but assaulting multiple actresses. So time and again, her character has been called into question. So it's going to be very difficult that the very things that started to be said about Blake during the time of the promotion of the movie up until now are the same criticisms. So how is she going to prove that there was some impression that the Wayfarer parties caused that's different from her true identity or her known character? That's going to be a real struggle because it is well documented. Just a side note, I've seen a lot of comments made today about how this rumor that there was some fighting on the set of Avengers, and how that even though no one was initially named, the rumor became accepted fact, basically, that the fight was between Ryan and Robert Downey Jr. That's all it took to really escalate a lot of bad talk aimed at Ryan. In a matter of a few days, with nothing more than a rumor, he's quickly being called out on TikTok by people who have not previously criticized him. And these things are getting literally millions of views, millions of comments, millions of hearts. This is the society we live in, and I've talked about that so many times, trying to explain how this happened to Blake. That it's organic, that we live in a cancel culture and that especially amongst the young people, they do not have the Hollywood celebrity culture like previous generations have, and they are very big on holding people accountable, even themselves. These things happen organically, and they just snowball once someone becomes a target. Now, as I said, this one was twofold and involved the actual malice, because she's a public figure. The fourth one, there has to be harm shown. Like I said, real, provable harm. Notice it says the plaintiff was harmed and sustained harm to property, business, profession, occupation, including money spent as a result. What does this mean? Not just a passing thing, but sustained harm, and these are all provable things. You have to prove your distress, or you have to prove you suffered harm. Now, how do you prove that your property or your business or your profession or occupation were harmed? You have to have receipts, and we're going to talk about that more in a moment. But the final fifth thing is that the conduct by defendant, in this case the Wayfarer parties, was a substantial factor in causing the harm. In a legal sense, substantial is a big word. That means you have to take these receipts and you have to prove that you suffered some kind of big harm. If it was emotional distress, you're going to need medical records, which she avoided for her actual emotional distress claim. If she's going to claim that it affected her business, she's going to have receipts. Now, there's problems with this because she just put out a big claim about how much money her hair care products made. It was a very stupid thing to do when you're trying to claim that this alleged retaliation harmed your business. And she specifically has named her hair care as being harmed by this. So she's got a lot going against her. It's hard enough to prove this in the first place, but when you're out there bragging about how well your company's doing, you've just destroyed your own claim. Now, the rest of this, we'll go through several situations we see in these case laws that are cited. And this one's really important. False light claims should meet the same requirements of a libel claim. That's huge. So just like defamation, one is written, one is spoken, but they have the same requirements to prove. This is not going to be easy. In the second paragraph up here, it says no case has been found that provides for presumed damages for a false light violation. And it shows the extent of it. At the bottom, it says placing one in a highly offensive false light will in most cases be defamatory as well. So that's why they often go hand in hand, as they do in this case. And in column 2, it stands or falls on whether it meets the same requirements as the defamation cause of action. Now, when you get to the part of the instructions where they have to sort out whether or not the defendant did commit these acts, the first question the jury has to ask is, did the defendant publicize information or material that showed, in this case Blake, in a false light? She will have had to prove that somewhere there's some statement on some website or some magazine that is absolutely traceable to these people. So this little stuff she's gathering now, saying, oh, in this chat, they were talking about contacting Perez. And that's not good enough. They're going to have to say, as a result of these PR people and Wayfarer people's actions, this particular description of Blake or this article occurred because of these people. In a real conspiracy case, this is very provable. As I've told you guys before, I cover a conspiracy case that happened in South Carolina. Those ties are being discovered as we speak. They are very real. There were bots. There is traceable evidence. In this case, it's all just, oh, they were having this conversation in chats. There is no direct link to anything yet that we've seen. So the jury's going to have to say, did Wayfarer publicize information directly? If the answer is yes, move on. Would a reasonable person in Blake's position consider the false light created by the publication to be highly offensive? Now, as far as defamation, truth will cure that. So whether she's offended or not, or whether a reasonable person would be offended or not, you can cure the defamation by saying, well, she did get married on a plantation with cabins that used to be the homes of enslaved people. She did say Leighton Meester was born in a cage. She did body shame Kirsty Flaw by speaking of her having a baby bump when she didn't. If the answer is yes, it moves on again. Is there clear and convincing evidence that Wayfarer either knew the publication would create a false impression or acted with reckless disregard for the truth? Again, you've got trouble with that word false. Are any of these things being said about Blake false? Number 4 is really important. Was Wayfarer's conduct a substantial factor in causing harm? A substantial factor is a major role. Are the things being said about her, was that a substantial factor? So that calls for them having to have had a significant contribution. Another way to put it is whether or not an injury would have occurred without the defendant's conduct. So was the impression made because of something Wayfarer said, or would this criticism exist without them? As I said, she's been criticized for these things over the years. It just greatly increased once people started to realize she might not be the person we thought she was, when they were disappointed in her form of marketing. So if you go back to when she started being criticized, first it happened not because of anything she did, but because people had a different idea of what they wanted Lily Bloom to be. That wasn't her fault, but it also wasn't Wayfarer's fault. The bigger criticism came when they saw her appearance. That didn't come from Wayfarer. They very much wanted her to succeed at the time, and in fact, no fighting had begun yet. That can't be blamed on Wayfarer. And the biggest thing was the marketing. Wayfarer was not a substantial factor in that criticism. They never asked her to make sarcastic remarks about DV victims. They never asked her to try to sell her hair care products when she was supposed to be promoting a serious movie. They never asked her to try to sell her booze while she was promoting a serious movie. They never asked Ryan to make that weird sketch where both he and his mother SH'd Brandon. Wayfarer was not a substantial factor in any of that. And then if the jury gets past all of that, it comes to damages, and this gets troublesome because normally this affects something with your job. She was fully paid for her role as Lily Bloom. She didn't lose any money for that. What's more, she hasn't made any claim as far as her being an actress. She would struggle to do that because she went so many years not consistently working. That's not a criticism. She chose to be with her young children as she was giving birth and raising them in that precious time. She's not to be criticized for that. But because she wasn't working regularly, she can't say, well, this is how much I normally make, and this is how many movies I normally make, and because of this, I haven't been able to make what I was used to making. She simply can't do that. Now, what about bringing in, she's trying to claim this loss on her hair care products? That is going to be very, very difficult because it wasn't like she had this established company that had so many sales and then after this supposed smear campaign happened, it made her lose sales. That didn't happen. It was a brand new company. She has no proof, no way to prove how much she would have made if this criticism had never happened. You can have a hopeful goal of what you think your company's going to make, but you have no guarantee how much your company's going to make to say, I suffered loss because of this. But not only that, like I said, this is her second time of bragging. She bragged before about the sales that she made when her shampoo first hit the market. And now she's bragged again about her continued buying. I think they said it's like 80% or something. It's really, really good. How are you going to claim damages in this situation? It's going to be very, very difficult. But that's not all that's going to be difficult. Looking at this chart, here's a very specific situation. As I said, false light does not exist in New York. When you have a diversity case like this, it's in federal court in New York, but you can apply another state's laws. However, New York is not like any other state when it comes to applying another state's laws. They hate to do it. They basically refuse to do it. So we have case after case of diversity cases who tried to apply California law for false light in the Southern District of New York. 100% denied. New York does not recognize false light. They never have recognized it in a single case. They will not recognize it. She has a 0% chance of getting him to do it. And if he does, it's going to be extremely questionable because it's not done. Now, looking back at this chart, remember I told you the filming was going to be very important. Look at all of these causes of action, except for the top two. They seem to all require California law. Now, the breach of contract doesn't say specifically. That's going to be hard because although she supplied the rider contract, that's the 17-point return to production, she's never supplied her actual actor contract. She's going to have to do that, and there's big questions about that contract ever having been signed, so that has its own issues. The defamation, that doesn't give which rules it's falling under, but we know how hard that is, especially because she's a public figure. You can almost just mark that off. And the conspiracy doesn't define which rules it's going to fall under, so we're not going to touch that one today. But keeping in mind that the Southern District of New York and the Second Circuit is not going to honor California law. Now, what do you do in this case? If you have an actual claim, that doesn't mean it's dead. It means that they will transfer law to New York law or federal law. These Title VII, they'll be fine because they're federal, but these state laws are going to have to come under New York law. But a search of those was almost as bad as the search for false light. It's very dismal. She really would have stood a better chance to have kept this claim in California. The laws are better suited for this type of claim, and people would have rallied to try to get that 47.1 put in place. The more research you do about the Southern District of New York, or the Second Circuit as a whole, and their lack of willingness to take on another state's law, 47.1 has less than 0% chance of coming to fruition in this case. New York seems to think it's its own, not even it's just its own country, they think it's its own planet, that they don't have to listen to anyone else. Now, I tried to find an SH and retaliation claim brought to the Southern District that ended up applying California law, that used FEHA, or California labor law, or civil code. Never apply California law. If a claim does survive the motion to dismiss, like I said, it's transferred to federal or New York, but even that is very, very rare. Now, I found this one. This one is still in the process, but as we read it, you're going to see exactly what Blake will be facing when it comes time to apply law to this. Now, this claim goes beyond SH. It does have SH and retaliation, but it also has pregnancy discrimination. So it's a better case in many ways than Blake's. This woman claimed, in addition to the SH, that she was given a bad review and fired for being pregnant, which is a protected condition. Those claims survived the motion to dismiss, and those are the ones that continue in the case now. But let's see what happened to the other claims. These are her claims, and I want you to think about Blake's claims as we go through these. So this claim is against a woman named Anderson. This is her boss, so very similar. They travel for work. She claims that Anderson abruptly launched into a graphic discussion about sex, telling her sexual desires, this is graphic, that she liked being choked, bound, and disliked anal. How does that compare to Blake's claims? She goes on. She described her interest in sleeping with multiple people at the same time, that she kept a bucket list of her targets, that she goes to parties to meet people for sex, that she's in an open marriage, and that her husband would have sex with other women. She tells her about her desire to sleep with more women and to keep exploring sexually. Plaintiff viewed this as an obvious effort to lure her into a sexual encounter. She continued describing an encounter she'd had with the founder of one of the main customers and asked her for advice on the encounter. Plaintiff did not welcome the conversation, didn't want to displease her direct manager. As it was her first week, she attempted to deflect the discussion, saying it was up to her how she proceeded and to consider her children. The next day, Anderson asked her if she could borrow going-out clothes. Plaintiff agreed, and at the end of the day, Anderson insisted on returning to the hotel to return the clothes. Plaintiff figured this was going to bring more overtures, so she tried to avoid it by saying, no, bring them back tomorrow. Anderson refused. Upon returning to Plaintiff's hotel room, Anderson took off the borrowed clothes in front of Plaintiff until she was wearing only a bra and underwear. Plaintiff asserts that Anderson clearly expected the two would have sex. Plaintiff feared retaliation and conflict with Anderson, so she excused herself to the bathroom and called a friend, asking them to go to her hotel room. After exiting the bathroom, Anderson proceeded to describe to Plaintiff that she intended to have an extramarital affair. Anderson touched her breasts and asked Plaintiff whether she thought Anderson should get a boob job. Wanting to avoid conflict, Plaintiff stated that the surgery was not necessary, but that it was ultimately Anderson's choice. Again, how do these claims stack up against Blake's? While on a business flight to Los Angeles, Anderson again brought up her sexual relationship with the client. She subsequently brought up her sexual encounters once more in March of 2023, while Anderson and plaintiff were in Australia for work, describing to plaintiff an encounter she had with a female coworker late at night. At that point, Anderson also made a series of sexual comments about their colleagues, describing and opining on their sexualities. Afterwards, Anderson turned her sexual focus to plaintiff. Anderson expressed her desire to date more women and her disdain for anal sex. For the rest of their time in Australia, plaintiff tried to distance herself from Anderson. These are big claims, right? That same month, Anderson advised plaintiff she would be leaving. Plaintiff told Anderson that she was pregnant and the pregnancy was high risk. Anderson questioned whether she could do this job. Plaintiff said she could. Anderson was skeptical, and she questioned her motivation to be in this role and then gave her a false negative performance review, according to plaintiff. She says she had never received any other negative feedback ever. She'd only received positive, and so she felt this was discrimination for her being pregnant. She went to HR after that point to complain about the review. She also revealed the inappropriate conduct. She ends up fired. And so, in addition to those claims, she files this discrimination claim. To demonstrate that, you have to demonstrate that you're a member of a protected class, were performing competently, suffered an adverse employment action where the circumstances suggest a discriminatory motive. In order to claim retaliation, you have to show that you engaged in protected activity. So she reported both the improper conduct and the unfair review to the employer, subjected the employee to an adverse employment action. She was fired. And the causal link between the protected activity and the employer's action. So she has two of those. She was pregnant, discriminated against. She reported harassment and discrimination and was fired. Very good links to these, but that's not all she has to prove. For this FEHA claim to be applied to a non-California resident, which she wasn't, the conduct has to take place in California. It should not be construed to apply to non-residents employed outside the state when the tortious conduct did not occur in California. So, Blake is not a resident of California. She's a resident of New York, which is why she filed her claim in New York. The last couple of days of filming happened in California, but she, by her own admission in her complaint, said that none of her claims happened after the 17-point list. So, it's given that nothing happened while filming in California. So these are some big issues. Keep these in mind. So the discrimination and retaliation claims under FEHA fail to meet the territoriality standard. The claims arose from alleged discrimination that occurred in New York. She was neither terminated nor retaliated against in California, and her place of employment was not in California. This is all the same with Blake. Plaintiff as a non-California resident employed by a non-California employer, Wayfarer is a California employer, but the employment did not take place there, cannot bring these claims stemming from action taken in New York. Accordingly, the employment discrimination and retaliation claims are dismissed without prejudice. These were big claims, but look what happened to them. Now let's move on to one of the SH claims, the one that fell under FEHA. There are two forms of workplace harassment. That's quid pro quo and hostile or abusive. So to bring a hostile or abusive environment, a plaintiff must show, and there's 3 prongs to this. She was subjected to verbal or physical contact. That was met in both cases. 2, the conduct was unwelcome. Again, the claims that they've stated that have not been proven, but that's what was stated. In both cases, they stated it was unwelcome. But now the 3rd prong, the abusive conduct was sufficiently severe or pervasive so as to alter the conditions of her employment and thus creating an abusive working environment. The question of where there's an abusive or hostile work environment is determined from the totality of the circumstances. The plaintiff must prove that the defendant's conduct would have interfered with the reasonable employee's work performance and would have seriously affected the psychological well-being of a reasonable employee and that she was actually offended. So how is that determined? As with everything with law, they put these standards in place so you can measure these things, so that it's not left to each individual judge with each individual case to try to determine this just on his own opinion. 1. The nature of the unwelcome sexual acts or works And it says, generally, physical touching is more offensive than unwelcome verbal abuse. 2. The frequency of the offensive encounters. 3. The total number of days over which all of the offensive conduct occurs. And 4. The context in which the sexual harassing conduct occurred. So we saw her state that because she felt uncomfortable, she avoided her. She was able to do that. She wasn't being constantly bombarded to the point that she could not continue her work. As she herself states, she always received good reviews of her work. So obviously her work was not affected. Has Blake made claims that she was unable to finish her work or to do her work well because of these claims that she's made? One of the biggest claims she made is the dance scene, but we saw her be able to finish that scene, and when it was finished, no one else wanted it, she asked, "Can we shoot again while you focus on my shoes?" Obviously, it did not affect her ability to do her job, because if it had, she would not have not just welcomed or allowed, but requested, demanded really, film this again, with me in his arms, up close looking lovey-dovey, just to film these shoes that I'm wearing. Again, it has to be pervasive. The total number of days, the total number of times, the context. We have him calling her clothes sexy because she invited that word into the conversation to describe her clothes by saying she wanted her clothes to look sexy. We have her using expressions like ball busting and playful, never with teeth, talking about suppositories, inviting them to come into her trailer while she was breastfeeding or pumping. Context matters. If you don't want someone to speak in a sexual way or about sexual things in your presence, then you yourself cannot speak that way. When you do, you're inviting it. You can't use such speech and then hold someone else accountable for doing the very same thing. Now, the judge says it might be that plaintiff can amend the complaint so as to demonstrate harassing conduct and the consequences of such conduct that would give way to this claim, but as currently written, the complaint does not plausibly allege such a claim. Even with all of those things that she claimed, that the judge has to take as truthful when he's making this decision, with all of those things, it didn't meet the standard. Accordingly, the court grants defendant Immutable's motion to dismiss plaintiff's FEHA sexual harassment claim without prejudice. So he's saying this doesn't cut it. If you can come back, amend it, describe it in a way that does demonstrate it, you can try that, but the way it is right now, no. And these claims, like I said, look so much worse than Blake's claims. But remember, that wasn't the only claim. There was also the federal claim under Title VII. So the judge considers these as well. To state a claim for retaliation under Title VII, a plaintiff must generally show, this one has 4 prongs. He engaged in a protected activity by opposing a practice made unlawful by Title VII. 2, his employer was aware of that activity. 3, he suffered a materially adverse employment action. That didn't happen with Blake. 4, there was a causal connection between protected activity and the adverse employment action. So Blake is trying to claim, in her retaliation claim, she wasn't fired or anything like that. She's saying the retaliation was to defame her character because of the protected activity. But in addition to everything else she has to prove that there was a causal connection, that it was a direct result from her making this claim. So first of all, she has to prove that there was a report, either officially or unofficially even, a report about SH, and that this defamation, this retaliation came directly from that. So not only does she have to prove that the claim was made, but she has to prove that this defamation that didn't happen, she claims that she reported it in May, but this supposed retaliation didn't start till August. Is that a causal connection? Or were they defending themselves for a different reason in August? Plaintiff bears this burden. Now it talks about New York law. Similarly, it makes it unlawful for an employer to retaliate or discriminate because she has opposed any practices forbidden under this article, or because she has filed a complaint, testified, or assisted in any proceeding under this article. And so this federal and this state law is governed by the same standards. So, if Blake's California claims are dismissed, it would transfer to these two, the federal and the New York. But we've got more to consider. It again mentions when a protected activity is closely followed by an adverse action. It has to be close enough to be causal. Was months later close enough, really? And unlike what they're trying to portray, as I said in my last episode, I think James Vituska's messages say something completely different than what they're claiming. He's talking about the conversations in August that he had with Leslie Sloan, and that she never mentioned whether he meant SA or SH, either one, that scrolling through, and he sent a copy of that video of him scrolling through, that it was never mentioned. They were talking about conversations that happened in August. So it really does look like nothing of that nature was claimed until December, when she filed her CRD complaint. So do we even have a protected action? As of now, we don't know. And if we do end up finding one in May, is August closely following? I don't know about that. Now, they say in this case, plaintiff successfully states the Title VII and then the New York claims because she complained to her employer regarding the discriminatory treatment that she experienced on the basis of her pregnancy. The employer was aware of this. She did go to HR with this complaint, and then she was terminated. So this was causally connected, given that the protected activity was closely followed by the adverse employment. And it notes that causation requirement of retaliation claims can be satisfied where protected activity was followed closely by discriminatory treatment. And you'll note that during this time, Justin was still hoping for the best. He was speaking highly of Blake in interviews, and it was actually Blake that was out there speaking to the rest of cast because it's obvious they changed their opinion of Justin. They unfollowed him. They wouldn't say his name in interviews. None of that was happening on Wayfarer's end. It was after all this stuff started happening that he employed crisis PR that was obviously aimed at Blake's behavior towards him, not about a claim that no one can prove ever occurred. And surely, while Leslie Sloan was busy leaking that the cast and crew hated Justin, surely if that claim was in the works, that would have been said at the time. Instead, they were busy trying to get Justin and Jamie to sign something saying that things happened on the set and it was their fault. And surely, Ryan, with the way he's described what kind of man he is holding his wife's pain, wouldn't have simply asked them to sign this document. It would have been a whole lot more happening. Now we go to New York law, because the California standards failed. So he transfers the claim to the New York state law. Did she do any better here? It says for a plaintiff to bring a claim under this New York law, the conduct at issue must fall within the statute's territorial scope. In order for discrimination to occur within New York for the purposes of the New York law, it must be shown that the unlawful discriminatory practice originated within New York state, that a discriminatory practice affected the terms, conditions, or privileges of plaintiff's employment within New York. At the bottom, they say holding that conduct occurring in California by a foreign corporation is not within the scope of the New York law, noting that the New York law does not apply to conduct outside of New York state. So her California thing is not going to hold up. If it transfers to New York's not going to hold up, because none of this, by her own admission during the deposition that we went through already, none of this happened in New York. So now what law is left? The California laws are all scrapped. The New York law is now scrapped. All you have left is the federal. Her claims are falling apart. It goes on that the plaintiff's New York sexual harassment claim fails as it does not satisfy the territorial requirement. The instances occurred in California, on a flight to Los Angeles, and in Australia, not New York. Plaintiff has failed to plausibly allege a New York sexual harassment complaint. Defendant's motion to dismiss is granted without prejudice. And so all that's left in this case, and in Blake's case, is the federal claim. So he moves on to that. He says it's actionable under a Title VII when the workplace is, catch this word, permeated. Think about permeated. It's not just little things here and there. It is saturated. It is everywhere. It is in the very fibers of the workplace, with discriminatory intimidation, ridicule, and insult that is sufficiently severe or pervasive to alter the conditions of the victim's employment and create an abusive working environment. Now here's where this really sucks for Blake. This is all on film. It's not just on the actual movie film. There is footage of people walking by, seeing this movie being filmed, and recording it. And what do we see in every single one of those videos? Blake pushing for her way and telling Justin what to do. Those hands flapping around, The mouth running, the looks on the face. At one point, she grabs his body and slams it into hers to show him how she wants him to grab her. It's all documented. Does it show the workplace is permeated with intimidation? Discriminatory intimidation? Ridicule, insult? Is it severe and pervasive? Is it an abusive working environment? Because when you look at the footage, he's the one that looks like he's being abused. This is a higher standard than the others we've come across, and this is the only one that she's going to be left with after the others are all disposed of for the reasons we just saw that this one was. Now, what does it say? Whether an environment is hostile or abusive depends on the totality of circumstances, and courts must consider a variety of factors, including the frequency of the discriminatory conduct, its severity, whether it's physically threatening or humiliating, or a mere offensive utterance. Did you catch that? An offensive utterance is something that somebody says that you are offended by. That does not meet the standard. That's not enough. It might make you uncomfortable. It might be morally wrong, but it doesn't meet the legal standard. And whether it unreasonably interferes with an employee's work performance. We see her continuing the performance, never claiming that she couldn't. Important context is that as a general matter, isolated remarks or occasional episodes of harassment are not actionable, but rather the incidents of harassment must occur in concert or within a regularity that can be reasonably termed pervasive. And just like that, she loses the federal claim too. So this plaintiff, as will Blake's, sexual harassment claim fails to meet the standard needed to survive a motion to dismiss. Considering the totality of the circumstances, the court finds that the sexual harassment Anderson subjected plaintiff to did not alter plaintiff's condition of employment and did not create an abusive working environment for reasons the court dismissed. Plaintiff's FIHA sexual harassment, that plaintiff avers 4 separate discrete instances of sexual harassment that taken together do not allow for the harassment to be termed pervasive. Plaintiff pleads that she was uncomfortable with the graphic sexual discussions and with Anderson's sexual overtures, but the complaint as currently written does not plead facts that would demonstrate that Anderson's conduct was threatening or humiliating, even though she stripped down to just her underwear, touched her breasts, alluded to wanting an interlude with her. Even that did not meet the standard. That's how lofty it is. And he grants the motion to dismiss against the plaintiff without prejudice and says if you can amend your complaint, just like he said the others, if you can amend it and demonstrate it, we'll try this again. But no. So as it stands, the discrimination for the bad review since she was pregnant and being fired for complaining, those still stand. Those met their standard. But all of the rest of these are no longer in play, and this case is still ongoing. So going back to her remaining causes of action, we look at them all, and we see how they were just one by one crossed off the list. And I believe based on this and many other cases, this is exactly what's going to happen to Blake after all of this. And the chances of the Southern District of New York accepting Rule 47.1, just impossible. It's not done. And especially with this rule not ever having been used even in its home state of California, it's not going to happen. Now, I've heard people say that they think the judge knows, as he would, that Blake has no case. He's familiar with all of this. It took me days and days of research to come up with this, but this is his job. He does this every day, and before he was a judge, he practiced for decades in New York. He knew at first glance all of this stuff, that this is not a case that's going to be won by Blake Lively. And so a lot of people have thought that maybe he knows that, but that he's making decisions with that knowledge. And so for the first time today, I started to really consider that. I used to dismiss it immediately because I felt like his disdain for Wayfarer was so strong, and that wouldn't need to be there just for him to simply be allowing Blake to fully try her best at this case so that she couldn't claim that he did something wrong that she couldn't appeal later. He has a very low appeal rate, which is what every judge wants. If judges make decisions that keep being overturned in the Court of Appeals, it looks like they're not making good decisions. So naturally, he wants to keep it very, very minimal that his decisions are overturned. You can see by how detailed he is when he makes a big decision. Those orders are so long. That motion to dismiss order was 132 pages or 138, I can't remember. It was a lot of pages. I do think he got some of those things wrong. in my opinion. But I think it could be possible that this is what he's doing, that he knows she doesn't have a case, but he doesn't want to be accused by her of doing something wrong or get his inevitable decision overturned in an appeal. But that would still make me upset because of the way he treats Wayfarer, and I do think he's made some questionable decisions, and every time he does, and every time he treats Wayfarer the way he treats them, it gives the public a certain impression. It also gives Blake's attorneys a chance to go running to the media and report this stuff. Every time that happens, it heaps more pain, not just on the Wayfarer parties themselves, but on their loved ones. That would be cruel of the judge, to just be looking at his own record and not considering that his treatment of Wayfarer or some of the decisions he's made are causing real harm to real humans. So that would still be upsetting to me. He doesn't have to treat them in such a way just to ensure that she gets to use every opportunity to attempt to try this futile case. But all we can do at this point is speculate, and we've got 6 months left, so we're over halfway there. And that's if it survives summary judgment, which will be coming up in just over 2 months. So this might all be coming to an end sooner than we think. So let me know what you guys think in the comments.